Hello, everyone. Welcome to the AIA Contract Documents webinar on the fundamentals of an effective custom residential contract. Also note that this webinar is worth 1 LU credit, and you can reply back to the email, the follow-up email with your AIA member number, and you will receive that credit. With that, I'll hand it over to our moderator today, James, to take you through the rest of the presentation.
So my name is James Germano. I'm going to be your master of ceremonies this afternoon. Thanks for joining us. Just a couple housekeeping matters. The first is we just have to give our standard disclaimer, letting you know that we're not providing this presentation today for legal advice. It's not intended to create an attorney-client relationship. You shouldn't act on this information without the advice of counsel. And the best thing for you to do, if you have specific questions about your contract or your project, is to seek the advice of an attorney who is licensed in your jurisdiction who can give you that appropriate advice. One more disclaimer is that this presentation is protected by U.S. and international copyright law. So reproduction, distribution, display, and use of this presentation without our consent is prohibited. So let's get into the substance of what we're going to be learning about today. Our learning objectives are fourfold, and these are just sort of broad brush learning objectives, and we'll go into some more specifics obviously throughout the day. But the first thing that we're going to do is we're going to review the risks that are unique to custom residential projects, and we're going to learn how to minimize them through certain contract provisions. Next, we're going to examine how an understanding of each party's unique roles and responsibilities will reduce project delays and disputes. And specifically, we're going to talk about some contract provisions that come into play when you're allocating those roles and responsibilities to allocate risk. Third, we're going to identify key contractual modifications that can help alleviate risks and the challenges of residential design and construction to achieve a successful project. And those modifications, again, we're going to be talking about those in a little bit more general and broad brush, and more focused on the specifics and the nuances of this new suite of AIA contract documents. And lastly, we're going to tell you where you can get additional resources to help develop an enhanced understanding of these residential contracts and other risk management techniques and issues that can benefit you and all project team members. And that'll be at the end of today's presentation. So without further ado, we're going to introduce the two very knowledgeable speakers that we have for today's presentation. And I think you will find their presentation to be very pleasant and very knowledgeable throughout, as they both have a very intimate understanding of these documents. So first, I will hand the mic over to Mr. Bell to introduce himself and tell you a little bit about his knowledge and experience with respect to these documents. So Michael.
Well, good afternoon, everybody. Thank you for attending today. As Jimmy said, I'm Michael Bell. I'm both an architect and an attorney, but definitely foremost, I am an architect. I spent 6 years of my life as a law student and attorney, but otherwise I've practiced architecture, almost 30 years of it as the principal of my own firm, Bell Architecture in New Orleans. My work is almost exclusively custom residential. As an architect lawyer, I've remained fascinated with how design and construction interrelate with the law and contracts. That's why I'm about to wrap up my 13th and final year on AIA's Documents Committee. I chaired that committee in 2017 and 2018, including during the 2017 release of our flagship documents. That was certainly a high point of my service on the committee, but this week might be an even bigger personal milestone. On Tuesday, we released two documents that I've spent the better part of 2 years helping to write for my custom residential practice, and I look forward to using them for the rest of my career as a custom residential architect. And that's gratifying to me, but it's also gratifying to share these documents with you all. Leonard Cady is delayed in joining us, and I will take some of what he was going to talk about, I can talk about, and he will hopefully join us at some point. So next slide, Jimmy.
Sure. Thanks, Michael. So let's talk a little bit about the objectives of AI contracts generally. Michael?
Yeah, we do want them the industry to treat them like as a standard. We get use and feedback and learn from them and continually modify them. This is a committee of AIA that's supported by AIA staff members, and we work pretty hard, putting a lot of hours into this, and we try to make these contracts fair and balanced. If we favor our architects, nobody would use them. We have to balance the competing interests of various parties who sign these agreements, and we need to put risk where it's best managed. And that really is, you have to consider which party can best afford it. And we've been successful over the years in doing that. Next slide. And AIA has published these documents for over 130 years. That old document on the right is a general conditions from 1911. First owner architect agreement came out in 1917, and basically these documents have evolved to reflect the changing world of design and construction, including a lot of litigiousness. But today we enjoy nationwide application of these documents, and there's over 200 of them. You might ask why it's important that you have a thorough and current contract, and I sure hope that you're using written agreements for your project. But let's talk briefly about the importance of current and thorough written contracts. By the way, AIA uses the term agreement, and you'll hear me talk about agreements and contracts interchangeably, but AIA likes the friendlier agreement in its titles, but it's really the same thing as a contract. But your contract or your agreement is essential for risk management because it allocates the risk to the proper party, partly through insurance and partly through the contract provisions that address scope and the responsibilities of the parties. Contract law is fluid, and it's important to use a current contract to keep up with it. The nature of practice also changes. A recent example is the sharing of digital models. There are, of course, issues with that, but that's part of how things are changing. Contract is also a way to educate the client about the design and construction process. Many, if not most, residential clients have never worked with an architect. We suggest that you walk your clients through the contract so that they will understand what to expect and what they're required to do, and they will appreciate that. A thorough contract also tells the architect what to do. Don't underestimate how helpful that can be. A good example is if you look at the 9 paragraphs in a B101, which is the long owner architect agreement, covering what the architect does during the schematic design phase, you'll find the architect immediately in schematic design evaluates the owner's budget, program, schedule, and site, and reports back as to any issues. When the architect provides the schematic design, she also tells the owner what she thinks it will cost to build it. Many an architect has fallen so in love with the project that she forgets these steps, and that can cause problems later. You must address cost and document it, or you may end up with an angry owner who doesn't feel like he must pay for a design that he can't afford to build. If your agreement is a short one and doesn't outline the steps of your services, the owner is free to imagine what your services are going to look like, and that owner may have different ideas about your responsibilities as to budgets and other things. So I want to give you a little background as to AIA's efforts to help the custom residential industry. Back in 2017, we sought to gather information so that we could help as much as we could. We sent out a survey to the knowledge groups, SPP, SFX, and CRAN, and the members of that. You may have seen it and hopefully responded. I know we get a lot of surveys. We got back almost 400 responses. And we asked several things, like number one was, well, what type of agreements do you use for custom residential projects? We asked, what modifications do you make to AIA language? We asked, how do your residential agreements differ from those for other projects? And we asked for suggestions as to how to make AIA agreements better address residential projects. What was really scary to us was that 50% of the respondents were using letter agreements. And we found some more bad news was that of those using AIA documents, most were using the very cursory B105 and A105. So we wondered and asked, why the reluctance to use more thorough documents. And really the top 3 reasons architects gave for using a short contract was that they said that anything longer or long is intimidating to clients. They said that AIA documents, the ones who, some of them did, said AIA documents were not sufficiently tailored to residential projects, and some complained they were too legalistic. But I'd suggest to you, we see clients sign licensing agreements, automobile purchases, and the like all the time. That includes the documents to purchase and the mortgage on this marvelous home you're designing. And that's what they expect to do. Owners want to know what to expect from you. They appreciate knowing, what if we're over budget? What do I owe if I suspend the project? I think that they appreciate that their architect is a business person and not just an artist. They're spending a lot of money with their architect, and they want to be confident they're spending it wisely. It was pretty clear to us that clients aren't intimidated. Most architects just don't want to address this in the detail that it deserves. We all work hard, and nobody has time for this that, admittedly, most of you don't find all that interesting. That's for some of the respondents' claims that they said the AI documents aren't residential enough. The most common edits they said they were making had to do with consultants and who's hiring them, et cetera, dispute resolution provisions, arbitration versus litigation, et cetera, are adding a limitation of liability. Their edits looked a lot like you might make for a commercial project, not so much about the peculiarities of residential. Custom residential and commercial projects are just fundamentally the same, such that we can start with the same contracts and make a few edits. This assumes the architect is providing full services through construction. Of course, all of this assumes that I'm talking about here, that's the scenario. You're doing full services all the way through construction. And of course, you probably know that we would advise you not to do anything less than full services. Be very careful about doing that. But that's a discussion for another day. So letter agreements. So for 4 years, I've been presenting to AIA members, mostly at convention, about and telling architects why AIA's B101 is the best agreement that they can use for custom residential work, and why letter agreements and even the shorter AIA agreements are almost always insufficient. The biggest problem is that top line there, unanticipated items, the what ifs. That is what maybe half of a long contract covers. You don't need it until you need it. At the most basic level, we see letter agreements that architects write and develop over the years, and the basic agreement says, this is what you'll get, and this is how much you'll pay us. There's a general awareness among architects, I think, that it's probably wise to say more, and over time, architects will add to their basic letter agreement provisions that they realize might be helpful. Unfortunately, these realizations sometimes come from learning lessons the hard way, and that can be costly, and you're still leaving other things out, possibly dooming you to learn the next lesson the hard way. So I urge you to use a tried and true contract rather than, to build a new one. I hope you're familiar enough with AIA documents to understand how part of what we're showing here is which owner architect agreements coordinate with which owner contractor agreements. You can see on the left, the owner architect B104 goes with an A104 owner architect agreement. Prior to this week, on the left were your choices for an owner architect agreement. Many of you are using B105. You might think it's short and it's a published document, so it must be fine. But most of the time, it's probably not. The other thing we're showing here is that when you choose a contract, you should analyze critically the scope, the complexity, and the risk of your project. You will find that B105 is usually not appropriate. And you'll find that B101 is almost always the best bet of the three. And for this reason, our new custom residential agreement looks most like a B101. And so for the next 3 slides, I'm going to walk you through some examples of this analysis. They are all real examples from my practice. We'll look at the B105, the B104, and then the B101. The B105 is for low risk, simple projects. We started calling it short form in 2017. It had been called an agreement for residential or small commercial projects, and that probably contributed to its overuse on residential projects that were too big and too much for this document. It really exists for the most minimal project and really It exists because residential architects, way back when it was first published, clamored for a short document. But there's a lot missing in it, and you should look critically at it. I'll give you an example, though. It's not that it would never be used, and I've used it. I'll give you an example when a B105 might work and when it worked for us. I have a sister-in-law who, we have it gets wet in Louisiana, and we have she had some rot problems on a front porch overhang. And the project was just to design a simple overhang that would rid her of this ongoing maintenance issue. So like I said in the last slide, before choosing a contract, just looked at the scope, complexity, and the risk of the project. And the scope, is that it was really simple to draw. I drew a floor plan, a section showing some flashing, a little framing information. And we knew what we were going to draw and build, so there was no need for phasing design into SD, DD, CDs, and which B105 does not do. And we knew who was going to build it, so we really didn't need the bidding and negotiation phase, which B105 also glosses over. The complexity of the project, this project had a footprint of about 10 square feet. It's very simple, and the risk was low. It was my sister-in-law. So with low scope, complexity, and risk, B105 worked just fine for very simple project. Moving on to B104. B104 was before 2017, we called it an architect agreement for projects of limited scope. That really was not the best title either. And now we call it the abbreviated form of agreement. It's basically a B101 with the scope portion kind of really shortened. So abbreviated is the proper term for it. It captures what it is about. The B101 has only 3 phases of architect services rather than 5. The biggest drawback, is that it's missing a lot of the scope where the architect tells the owner exactly what the architect is going to do. It's coordinated with the A104, which is a shorter owner contractor agreement, and that's a good thing. I'll give you an example of the B104. We did a family, or when it was appropriate, we did a family room addition with a $200,000 budget. It was in an old New Orleans neighborhood, tight lots, not a lot of latitude in the footprint. So we did our little analysis. Here we did, scope is about services as much, if not more, than the built, what's going to be built. We did want an approval of the design before we drew the construction drawings. But the design was not so complex that we needed the layers of design that SD and DD represent. We knew the identification of the contractor who was going to build it, so we didn't really need much spelled out as to B&N and bidding and negotiation. And B104 does not spell out much there. But the 2 phases of design and construction documents pushed us up out of a B105 and into a B104 because we did want these 2 phases. As for the complexity of the project, it was not a whole house or even multiple rooms. It was to be traditional, look like it was always part of the home. We weren't making a contemporary design statement here. To us, the complexity was moderately low, and the risk was average. We'd worked with the client and contractor before, so they knew our processes. We knew what to expect from each other. So B104 pretty much hit the mark for us. And on this project, I will share with you, I know your practice is different than mine, but I'll just tell you that, B105 or B104, rather than a B101, we do that. We use one of those on maybe 1 in 10 or 20 out of every of our projects. Just, again, I know your practice could be different. Just keep in mind that AIA wrote the B105 and the B104 because architects clamored for short. So let's see, the next slide is B101, and as you can tell, I'm a fan of the B101. It's thorough enough to resolve all the what ifs. It has our traditional 5 phases of architect services, the names of them, and it also has a very thorough supplemental and additional services table. I'll say as an aside, that's a change in 2017. We just had additional services prior to that. They're all lumped together, but now supplemental services are those that are negotiated with the contract where ahead of time you plan on providing, whereas additional services arise during the course of the contract. B101 really, what I love, it just gives a step-by-step guide to all that happens or could happen in a project. And it served us extremely well in our custom residential practice. The much expanded description of our scope of services that's in B101 and not in B104, really, it does give that roadmap and it allows the client to understand what we will do, what we won't do without more fees. This protects the client and it protects the architect. And you really, I think everybody likes limiting the uncertainties. So I want to spend a few extra minutes on this slide, giving you examples of how a thorough agreement is your friend. You know, these situations really happened to me, and some of them may resonate with you as being similar to your experiences. So about 5 years ago, we had a project, a custom home. We discovered during CDs that the owner's surveyor mistakenly labeled a 14-foot wide utility easement on the side of our site as 5 feet. So we had to come up with 9 feet. We had to redesign a significant part of the project, shaving off 9 feet. And B101's Articles 1, 3, and 4 make it very clear that we were entitled to rely on information from the owner's surveyor, and the necessary revisions were additional services for which we were to be paid. I didn't have to get into a discussion with the owner about what would be fair. The contract said it for me. I'll add as an aside, just know you must ask for written authorization to provide additional services, and you should hear we had a very good reason for asking for them. Otherwise, you could be providing them for free. You know, another project, the owner wanted to sell his lot and assign his contract with me to the purchaser. That's something you don't see addressed very often in a letter agreement. 10.3 and B101 made it clear that they needed my consent to do this. I did not mind the assignment. We just wanted to design a new home, but a change of owners necessitates additional effort on our part in order to get things rolling again. I explained this and they agreed to the assignment on the condition that the new owner pay us for that added effort. I can't tell you how many times I've looked at B101's 4211 regarding additional services to explain how the owner changing his mind means we get paid to revise the design accordingly. In fact, this is one that I point out at the outset when I use the contract as an educational tool. I try to impress on owners we need decisions from them that they can rely on. Makes them look at our drawings a little harder. We always fill in a limit on site visits in B101's 423. We sometimes have to cite this limit when the owner goes with the low bid and the burden falls on us to work harder to get the owner what they contracted for. So I love section 6.6 in B101. It spells out what to do in a budget bust. It provides a reasonable roadmap for the parties to follow when this happens. This may require us to provide VE services without compensation if it's part of the fault is with us, but it requires the owner to cooperate too. It shows them the path forward, possibly saving them from their temptation to say, you blew the budget, you're fired. A fair amount of B101 Inc. addresses cost overruns, and I think we all know why. The provisions on this are very fair to both the architect and the owner. So I have lots of other examples that I could cite and go on and on about, these things that if we didn't have B101, we would have been having to argue about it and try to press our point about what's fair. As I thought through these examples, I compare B104 to 101. B104 does help with most of these examples, but not all of them. And B101, help with every one of them. And it really should be your starting point for it should have been your starting point for full architectural services on custom residential projects. But as of this past Tuesday, there's one document better. So I've seen that my co-presenter Leonard is with us, and so I think it'd be appropriate for him to introduce himself before going on to the next slide.
Michael, thank you. Welcome. I'm Leonard Cady, one of the authors of these new residential documents and the chair of the residential task group that created them. I joined the committee for a term of 10 years, and I'm at the midway point. Previously, I led several committees of architects focused on small firms within the AIA knowledge community, where we learned from and advocated for small firms and developed educational material for the AIA. My firm, Leonard Cady Architecture and Design, is located in New York City. We've been doing custom residential architecture for over 25 years, both here and abroad. I've been using AIA owner architect agreements since the inception of my firm and found their instructional value critical to professionally delivering architectural services. Many of us can recall from memory those articles and passages of our contracts that we value highly, for example, copyrights, payment terms, communications with the owner and the contractor, and the what if clauses. I'm very excited to now have 2 documents that are tailor-made for custom residential projects. So what is unique to these documents is that there are particular jurisdictional requirements, consumer protection, and client relationships that are different from the larger commercial projects, and particularly client relationships. And it's very important to educate our clients and really explain to them the process of how it is that we go about design services and how contractors then process our materials and use them in the construction phase. The new AIA custom residential documents streamline the contractual processes for architects by tailoring them for the distinctive requirements of the custom residential market. The suite includes A110, standard form of agreement between owner and contractor for custom residential projects, and B110, standard form of agreement between owner and architect for a custom residential project. These are the first documents published by the AIA specifically developed for use in custom residential design. Previously, architects and contractors have successfully used other AIA agreements for their custom residential projects. Small differences in custom residential projects, however, meant that some of the content was not relevant and could be ignored, while other information needed to be added. The new document titles have the word residential in them to communicate that they have been vetted for custom residential projects and will need fewer, if any, edits. The B110 descends from B101, the flagship agreement, and A110's evolution more closely follows A104. How is B110 like B101? The B110 was developed from the B101 standard form of agreement between owner and architect. They are similarly structured. In both agreements, the architect still provides basic, supplemental, and additional services. Basic services are comprised of the same 5 phases of service: schematic design, design development, construction documents, bidding and negotiation, and construction administration. Like B101, the 110 offers a variety of compensation methods, including stipulated sum or a percentage of the value of the work, or other, prompting the architect to insert another method such as an hourly rate, or a hybrid where, for example, an hourly rate for schematic design may be followed by another method of compensation for the next 4 phases. While the architect provides general estimates of cost and scheduling, detailed estimates are a supplemental service. How does B110 differ from B101? Many jurisdictions have laws that are unique to residential construction, often to protect the homeowner. The new documents include prompts to remind architects and contractors to include these provisions. Some examples include consumer protection warranties and related notices, lien laws, and licensing requirements. Jurisdiction-specific requirements may include sustainability, historic preservation, and zoning. Additional requirements may come from a homeowners association. How does B110 further differ from 101? Sustainability objective provisions are deleted. The sustainability objective is not located in the main body of the agreement, but can be included using the E204 Sustainable Projects Exhibit to allow owners to flesh out sustainability goals if desired. However, the architect is still required to consider sustainable design alternatives in the schematic design phase. There is no initial decision maker because it's unlikely that one would be required in custom residential projects other than the owners themselves. The agreements also reduce the requirements for digital data protocols and transmission because residential projects are generally less complicated than commercial projects with regards to digital data. The B110 does not include engineering as a basic service. This is an important distinction. Structural engineering, mechanical engineering, electrical engineering as a cost is not always quantifiable, especially in residential, and the program may change as the project evolves. Rebidding is an additional service. That's the next slide. Oh, the bidding and negotiation phase has been clarified to include one concurrent effort. The architect will assist in one round of bidding and negotiating under basic services. If the owner wants to send the project out to bid a second time, hoping to get lower fees, that would be compensated as additional services. The B110 also simplifies the record keeping requirements for the construction administration phase. In addition, the B110 clarifies that the owner will retain one single contractor to perform the work. If the owner elects to hire subcontractors directly as a general contractor, the architect would be entitled to additional compensation because of the additional work required to coordinate such a project. The owner is always required to provide the architect with a copy of the executed agreement between the owner and contractor. We talked about this a lot because occasionally architects have experienced situations where owners believe that they can save money or cut corners by having multiple primes. And it's a very complicated way of administrating a project, and it's full of risks. And we feel that this is an important clause here. The B110 further differs in the supplemental services. Inapplicable services were deleted. Services specific to custom residential were added. Engineering services are supplemental provided by the owner or architect. Unless listed as a supplemental service, the B110 presumes that mechanical engineering services, for example, will be rendered through a design build process, such as when a contractor lays out the HVAC system. Supplemental services are those services which are beyond those covered in basic services, but which the architect will provide. This could include programming, hardscape, interior design, or audio-visual security low voltage system design. From the list of supplemental services, which have been edited to reflect the most common services for custom residential, the architect selects which services will be provided by the owner or the architect. And you can see in this table, the highlighted ones are the ones that are different and not common to 101. Other differences. Insurance provisions are streamlined with simple infill prompts. Owner-contractor communication is streamlined to read, the owner shall endeavor to communicate with the contractor through the architect about matters arising out of or relating to the contract documents. Mediation guidelines are reduced to one paragraph. Owner-provided information now includes property and site covenants, conditions and restrictions, homeowner association requirements. And now we will look at the new residential construction agreement, A110.
Okay, so one thing I'd add, all those changes that Leonard just went through, we got that B101 from, I think it was 24 pages before, now it's 22. So it's still a lengthy and thorough document, but it's much more customized to what owner and architect need to agree upon in relation to custom residential work. So as Leonard said, we're moving over to the contractor side of this. This is the new standard form agreement between owner and contractor for custom residential project, the A110. the basics are, it's based on the A104, abbreviated owner contractor agreement. And that means that the general conditions are within the agreement. You know, that's kind of what I want to say here is that this to me is more than anything why we created this suite of custom residential documents. You know, as I've always said, I've always found that B101, the owner architect agreement, was good and thorough, but also easily adaptable, editable to adapt to my custom residential projects. And I'm not the least bit hesitant in providing one of those, I guess it was 23 pages. I think we cut 2 pages off, 23-page agreements to my clients. But even I cringed a bit at asking my clients and our contractors to sign an A201 general conditions paired with an A101, 102, or 103, because that can run 50 pages. And then unlike the B104 for the architect, I found the A104, the abbreviated owner contractor agreement, really sufficient for our purposes in custom residential. It came in at 25 or 30 pages rather than 50, depending on whether it was a stip sum or a cost plus project. I used to try to edit my B101 to coordinate better with an A104, and it could be done, but I don't have to do that anymore for my custom homes because now we have an A110 coordinated with a B110, and an A110 comes in at 25 or 30 pages, not 50, and it serves my purposes. And I'm sure that if you thought a B101 is long, you'll also be thrilled at this development. Next slide. So like the A104, you can edit the A110 for the contract to be stipulated sum or cost plus with or without a GMP. Those extra 5 pages I've alluded to, whether it's 25 or 30 pages, this agreement, come in only when it's a cost plus project, in which case you'll have to add the determination of the cost of the work exhibit, which is not relevant to stip sum projects, but is relevant to cost plus agreements. So the B101, I will say this, the B101 owner architect agreement underwent more modifications to become the new B110 for custom residential than an A104 underwent to becoming an A110. The biggest change was this simple fact of the coordination with the B110, as I just discussed. Otherwise, like the B110, the document prompts for jurisdictional requirements that are unique to building homes and consumer protection requirements, et cetera. We've also made some edits to acknowledge just how homes are built a little differently than commercial projects. Certainly, it's less likely that you'll be sharing BIM models. That's why the digital data protocols are simplified. But if you want, you can edit for that. Just look at the original documents. That's the A104, and then you can add that language back in if you want. Similarly, we find liquidated damage provisions are extremely challenging to referee in a custom residential project. I'm sure most of you can relate to that. And this is mostly due to the likelihood that the owner quite often contributed to the delay himself. There are a few other differences between the A110 and the A104, but these are the highlights. So these are the 2 new documents Leonard and I just discussed, and we think you'll really like these documents. The only thing we can't offer is brevity. As I'm sure is very clear to you by now, we don't think brevity is in your best interest. As architects, we want to lead the process on our projects, and we have to know a lot of stuff to do that. And you need to know your contracts, and you can't just gloss over certain things. And if you lead on your contracts like you do designing the project, procuring the contractor, leading on these contracts, you can take control of the trajectory of your projects and your practice and its profitability. Your clients will appreciate that you take them and their funds very seriously. So it's possible that you do other types of residential projects. There are around 200 contracts and forms and other documents that the AIA Contract Documents program publishes. And here are 3 that we thought might be of some use to you. A145 can be useful. I won't read the title, but you can see If you're doing architect-led design build for homes, that can be helpful. B107 could be useful if your client is a developer builder. Also, you could say the client is the owner and contractor, but use it with caution. It's the only document we have where we suggest that it's okay to stop at a permit set, but it's for a sophisticated and specific type of client, not just the homeowner. And then the B109 is more for multifamily than single family. Maybe some of you do that kind of work also. So besides just contracts, we have project management forms, including payment apps, change orders, certificates of substantial completion, and many more. There's 3 good ways to get them and to get the contracts we talked about today. We call basic single document, we call document on demand, and in it you can only edit the project data. The second one, custom single document, is a DoD Plus, where you can fully edit the document, Documents on Demand Plus. Or you can have a subscription if you really want to buy a lot of documents. I think that's probably not the best bet for most of us in custom residential work, but if you do a lot of documents, it can be worthwhile. AI does have many resources for you. Here are links for how you can learn more and how you may ask questions and get some help. AI has a growing set of videos on YouTube. We also have guides. I'm a big fan of these guides. I find a lot of folks don't know about them, but they're available for free on the AIA website. And there is one in particular applicable to what we talked about today for small projects. We hope to edit that and be a little more custom residential specific also. There's documents for condos, and that's a very helpful one. And you ought to take a look at what's available there. So let's leave this slide up. And Leonard, do you have anything further to add?
Well, I'd just like to add very quickly that we're very accustomed to contractors handing us large, voluminous pages of contract. That's why they're called contractors. And yet there is a sort of tradition to shy away from thorough contract agreements with clients. And I think clients are quite used to signing long documents, mortgage agreements, real estate transactional agreements. And so we would encourage you to think about the B110 in the same way that an owner would be completely accustomed to and willing to accept an A110 for construction. And it sets a good tone and really lays out very clearly the relationship between the architect and the owner, and then later the owner and the contractor. And clarity is really critical, especially when there are distracting elements, especially once construction begins.
Yeah, that's good. And I'll add, I tell you, over the years, having this dual background, I've said ad nauseum, I've used B101s, and I mean, maybe every 20th time somebody will say, "Oh, that's a long agreement," but by and large, they just get it, that, and I think they appreciate that I take it very seriously enough to show them exactly what we're going to do and spell out all the what ifs. And so anyway, I really get zero pushback on using the B101, and now of course it'll be the B110. And Leonard mentioned the title earlier, and you can't underestimate what that means. I mean, it's to the extent I got any pushback and somebody says, maybe this looks like it might be for a commercial project, which I did not hear, but if you can imagine somebody saying that, with the title of the document says a whole lot, and I think it instantly would give an owner a comfort level that, well, yeah, this is the agreement that you use for custom residential projects. That's what my project is, and you kind of cut through any barriers you might have there just by changing the title. And don't underestimate how important that is. As we found by looking at document usage, in the B105 I mentioned earlier, we called it for a residential project, and I think that gave everybody the ticket to use it. But we decided that we really need to do more education on when it's appropriate to use a B105 and when it's not. That's all I had. Jimmy, do you have anything?
We have
Or
time for questions.
questions?
Yeah, we actually have a couple questions that have come in, and I'd encourage everyone, if you do have questions, you can type them into the chat and send them along. So the first question, we've gotten this a couple of times. When will the B110 and the A110 be available for purchase?
And they became available on Tuesday. I've
That's
actually
right.
logged on and downloaded. I was so excited that they were there. I downloaded an A110 and B110 on Tuesday.
Yeah, they are available on our website. It's aiacontracts.org. And then you can type it into the search bar that you see, B110, and it should pop up and lead you to the ability to you can download a free sample always of all of the AIA documents. You can take a look at it and see what it's all about. And then if you so choose and it's appropriate, you can purchase it from there. Another question that we've had come in, Michael and Leonard, sort of a hypothetical situation. Would the B110 be appropriate for something like a small renovation? So like the example given here is a 3-season screened-in porch in a rear yard. Is that something where the B110 would be appropriate, or would that still be in the B104, B105 type category? What do you think?
Yeah, that's offhand, it sounds like it might be a 104 or 105 candidate. You know, we didn't take those and put the word residential on top, but they very much could still be used for, say, the smaller, the projects that are more limited in scope, complexity, and risk, as we talked about. And it seems like that could be a candidate for one of those. You'd want to go through that analysis, but it sounds like a simple project. They all do until you get into them.
That's right. Another question here, super interesting one that came in. And the question is this: what happens if you do a preliminary pricing exercise after schematic design? Are you able to flip the order of the phases to more accurately reflect a specific firm's process? What do you think?
Well, some cost estimating is anticipated, but not a full-blown estimate. It's prudent to do as much cost estimate exercises, as many as you can internally. But it's complicated as the project evolves and the program evolves. So I'm not sure how you flip the phases, because it's kind of linear process.
Yeah, linear was the word that came to mind when I heard that question too. I feel like that schematic, the Article 3 of the B101 sets out that linear fashion, and that seems to be the order of things, and not sure exactly how you'd flip that.
Sure, that makes sense. Thank you. Maybe one or two more questions. There are a ton coming in, so you guys have definitely stirred a good conversation about this. So well done. Can a contractor use their own contract form alongside the B110? What do you think?
I would. You have to be careful, and then we run into that a lot too. It's, you know, they weren't written to be coordinated. I don't want to be the guy that has to make sure they're coordinated. You know, there are some rules in the A201 general conditions, or the A104, I should say now, the A110, excuse me. Those general conditions that are built into that owner contractor agreement for custom residential projects. There are actually architects, there are statements about what the architect does and doesn't do. And that is probably the biggest part of the coordination of the two documents. But, you know, to me, it's rather than having to delve into it, you know, I make the case that these documents are coordinated, and, you know, you don't know what you don't know as to where there might be pitfalls where they are not in agreement with each other. But certainly you or an attorney or somebody could sit down and do an analysis and make sure it's compatible. But
I would add that a contractor's proposal sometimes carves out responsibilities or makes exceptions, and those are unique to the particular project, and they tend to be more of a specification level of contract. The A110 should be the primary contract, and any add-ons should be subordinate, where the A110 is always the governing language. And if there are terms that look similar to the terms that are already in the A110, then I would definitely avoid it for fear of confusion and neutralizing of the intended purpose of the language. But
just,
that's
I
not
will
always
add,
easy to do, because contractors have their own ideas and they have, they're set in their ways. So it can be a negotiation.
yeah, and they have their own attorneys too, who told them that this is the way that you should do it. So, I mean, it's a good question and a real issue. And I just definitely have to admit that, you know, we've seen the contractor win on that. And even though it's not fully coordinated with our agreement, I mean, I'll being with a legal background, I'll take the time to look for any issues and then fold because the deck is stacked against me. But try to use the A104.
Well, I'd offer this, sorry, Michael, I would also offer this, that when you put a project out to bid, ask the contractor to agree to sign the A110. And if they're in agreement, and those are the conditions under which they're bidding or proposing, then they're well aware that that's how they'll be proceeding when they go to contract.
That's exactly right. That's what we do. You put it in the front end of the specifications, that your project manual, that they're going to be signing an A110, and in theory, that means that that's what they've agreed to. But they'll still try to steer away from that, even though it was there in the spec book. But we try to take control of that dilemma early by putting it as a requirement. We do the same, you know, we say you've got to use the G702 and a G703 when you submit a payment request, or we're not going to look at it, because I can't tell you the challenges of forensic accounting on some of the contractor invoices we see. But anyway, I digressed.
Well, thank you both so much. We are out of time, and there are just to let you know, there are a ton of questions that have come in. So if we're able to get to some of those after the presentation, we'll try and get back to you. But I did want to highlight two comments that came in, and this is for Michael and Leonard. And it's more of a sort of a thank you from those of us that are, you know, work internally at the AIA Contract Documents group. The hard work that both of you put into making these documents a reality comes through. And these two comments, the first is, thanks for this information and these documents. They will be a game changer for me. And thank you very much for helping make these new documents available. Custom residential needs will affect many, many architects. So thank you. And I think those two comments really highlight the fact that you both did a fantastic job today and in putting these documents together over the last, you know, what was probably 3 or 4 years worth of work. So thank you both. Thank you everyone for attending today. That wraps up our presentation.
Jimmy,
I hope you found it helpful. Yep, Michael, go ahead.
One last thing is that I think that I believe that if we didn't get to these questions, I believe that we should tell our folks out there that you can go to the doc info service, and that's still on that screen there, and you know, ask some of these same questions, and hopefully you can be helped there.
That's right, and that's available 24/7. If you do have additional questions or comments or anything, you can send them to docinfo@aia.org, and that's where we track, just sort of as an aside, I'll take maybe 15 seconds and explain this to everyone. That's how we track edits that should be made in the next round of revisions, maybe 10 years from now, or comments like that come in. So if you're using these documents day in and day out, and you have a suggestion for maybe an improvement that can be made, go ahead and send it in. We store those, and 7 or 8 years from now, when we're looking at these documents to make a revision, that's where we go first. We look at comments that have come in, you know, well into the past, and see what can be improved upon. So feel free always to use that resource, Michael. Thank you for reminding me of that. So thanks again, everyone, for attending today. And that concludes our webinar.